Thank you. I first would like to thank Elisa Morgera and the Strathclyde Center for Environmental Law and Governance for the invitation. I am honored, and I also feel privileged to be here and having the possibility of discussing my experience as comparative lawyer with experts of international law, global law, and other disciplines. Let me say a few words on what was my experience before going to the presentation. I have a curriculum as comparative lawyer, and it was, I think, just by chance or for the love of the environment that I picked up environmental liability as the subject of my PhD. And so I began to work in the field of environmental law, taking into consideration a very technical question, liability for environmental harm. And then when I went on in my career, I inquired also on other legal institutions, private law institutions like property and contract in the development of environmental policies. And for this, I had to excuse myself in front of all Italian academia because nobody was understanding why I was doing that. I also did, during my career, a certain amount of methodological work, especially as far as legal translation and comparative law and language is concerned. And I will try to focus on some issues that emerged in the field of environmental law, taking into consideration the language issues that are concerned with that. So I have tried to divide my presentation in two parts. The first part, I will try with a very humbling perspective, because you can imagine that I cannot sum up in 15 minutes the methodology of comparative law. And the first thing I would like to say is that there is no perfect comparative law methodology, that each comparative lawyer develops its own at the end of the day, but that there are certainly some tools that are very well known by all comparative lawyers and that are generally used when you do comparative law research. In the second part, I will try to see if comparative legal methods can help in the understanding of global environmental law in global law research. So let me first begin with the typical question of the comparative lawyer. So the comparative lawyer generally asks himself or herself, what are the differences? What are the differences between my legal system and the other legal system that I'm trying to compare with? And of course, we are also looking at identifying common trends and convergences. And for example, many comparative lawyers have been trained in working on European legal systems in order to understand if they were converging to a common core independently from the introduction of various pieces of legislation from above, that is to say, from the European Union. But this idea of looking for convergences and common trends, it's something that we do, but it's, I would like to underline, it's not at the core of our work, which is and remains to find and look for differences and trying to understand why these differences exist. So we are very taking care of what is our past, what was our past as lawyers, but also as a member of specific legal traditions, and how legal development, legal change has happened during times. in this perspective, one thing that we are really eager to investigate, and we find a lot of literature on the issue, is to understand why the identical rule can have very different effects in one context as compared to another one. And I'm not dealing with very extravagant questions, or I'm not taking, neither I'm taking into consideration very different legal systems, but sometimes it's really a question of understanding how comes, for example, that directive on products liability had copied an American rule that was there in the restatement since years, and in the US, we have thousands of cases on products liability, and in Europe, maybe we have 3 per year. So that is something that comparative law is about. So we want to understand why these differences happen, and not differences only, of course, in the black letter rules, but on what is really going on in practice. And I have put the motto of the comparative lawyers, that is to say, verum ipsum factum. So we want to describe what is going on. We are not a specific political agenda behind it. There might be some comparative lawyers who have it, but generally comparative law research and comparative law analysis is really inspired by this motto. So I'm quite sure that this would, how can I explain, make many comparative lawyers very angry, because they would immediately say, oh, but there is much more than that in comparative law. But of course, I would like to point out at least some of the tools that we are using in order to see if these tools in particular can be a way of also collaborating with international lawyers, especially in the field of environmental law. So the first thing that I would like to stress is that comparative law research always involves history. So it's difficult to speak about a rule if we do not put it in a specific historical context. And there are some comparative lawyers who are even specialized in the field of comparing the evolution of a rule in different stages in different legal systems, so that comparative law research really goes hand in hand, dependent on what you are researching, with the work of the historians. Then 1 second, I will go into depth on all these tools, but just to give you a first idea. Then, of course, language and legal translation for us, it's crucial, because the first filter that we find when we want to know what's happening in another country is the filter of the language. And many of the comparative lawyers, of course, know different foreign languages, but when you have to compare with Chinese law or Indian law is not that bad, because there is always an English official translation. But if you want to have an idea of what is going on in radically different cultures, the filter of the language becomes always very, very difficult. And that is why there are a part of comparative lawyers who are really dedicated to anthropological research, and they are generally so much embedded in a specific legal culture that what is really happening is that at the end they devote their whole life to a specific legal system or to a particular legal tradition. I don't want to go too much into anecdotes, but the 2 young scholars, Italian scholars, that we sent to Japan in order to learn Japanese and Japanese legal culture, they are both married to a Japanese girl. They will never come back, but they are good correspondents of our group of comparative law researchers in Italy. Then one important tool that was developed by an Italian lawyer who is called Rodolfo Sacco and has been published also on the American Journal of Comparative Law is the theory of legal formants. Today the theory of legal formants comes like okay, but of course. But when 40 years ago it was developed, we shall see that it was really something that made people, especially of civil law countries, reflect upon what is the legal rule. And of course, when we identify the legal rule, we have the first basis to compare from one system to the other. Then there is a tool that is called legal process analysis. And of course, then there is the whole chapter about legal transplants. I will try to go into these 5 different issues very briefly, but just to give you an idea and maybe some example before going to the part where I try to adapt or where I try to find if these tools can be of any help into the research on global environmental law. So I would like to, I was considering the fact of putting scholars from any different country, but then for the sake of you and also of me, who did not have to translate everything, I put practically only things that were already published in English. So this is a quotation by John Henry Merriman, a very interesting figure among American scholars. He was professor at Stanford. He devoted part of his research, but long research on establishing which were the real differences between common law countries and civil law countries. And doing that, he was saying that we have to focus on legal traditions. And a legal tradition is not a set of rules of law about contracts, corporations, crimes, although such rules will almost always be in some sense a reflection of that tradition. Rather, it is a set of deeply rooted historically conditioned attitudes about the nature of law, about the role of law in the society and the polity, about the proper organization and operation of a legal system, and about the way law is or should be made, applied, studied, perfected, and taught. The legal tradition relates the legal system to the culture of which it is a partial expression. It puts the legal system into cultural perspective. This, I think, is nowadays reputed as the basis of each comparative law analysis. If somebody comes to you and puts a norm of this Italian civil code besides the norm of the French civil code and says it's the same, he's not a comparative lawyer. Caveat. Okay, so that is the point that I wanted to draw here. So comparative law research certainly does not consist in the mere juxtaposition of norms of one jurisdiction with norm of another, but aims much more at understanding how rules really work in a given legal context. That is why we distinguish very much between law in the books and law in action. And then I come to this point, legal translation. Well, here I must make a little bit of autobiography. Can you say that in English, autobiography? I had a very strict mother coming from south of Italy, who put us, 3 daughters, to a Swiss school. She didn't speak a single word of German. But we were all doing everything in German, but she was very much taking care of what we were doing. So she was very, very, well, taking care. And the first time in my life that I experienced what translation means happened when I was 11. And she asked me, so what is the teacher of history doing at this moment in your class? And I perfectly knew what the teacher of English was, the teacher of history was doing in the class, only that I was not able to translate it because it was in German. And so I began to think, okay, I am doing Völkerwanderungen. Völker means people. Wander means wander, walk, and go around. And so I translated to my mother, well, Mommy, we are doing this period where the peoples are walking around in Europe. And she said, people are going around in Europe? What is this? And I said, yes, you know this period when the Visigoths are coming and the people are going around in Europe, Völkerwanderungen. Ah, okay. You mean the barbaric invasions? And no, not the barbaric invasions. It's something different. The people are quietly going around in Europe. And so I don't think this is the right word in Italian to express that. And so after a while I said, well, maybe the Germans have another vision on what is going to happen, on what was happening in Europe at that time. And so when I came to comparative law, I began to have I had this flashback, say, yes, now I understand what happened to me when I was 11. Language as well as law are very culture bound. So comparative lawyer really need to deal with this issue. So I think that, I mean, I'm profoundly indebted to all the discussion that was happening here, but sometimes yesterday I was wondering, would this discussion happen in Urdu or Bengali or Chinese in the terms that we are dealing with it now? Because we would come from a so different and radical different perspective that, that maybe all the result of the discussion would be different. Anyway, of course, comparative lawyers know that when they are looking for the information they are looking for, this information is really embedded in one language that is different from the one that we are generally speaking. And it's true that English has become a global language, but nonetheless, when we do comparative law, English is not always really coming to play. Language is generally expressing a set of values, a set of ideas, and anyway, the culture of a particular legal system. So when we speak about legal languages and legal translation, we always try to stress how much the use of a specific language is shaping our way of saying and putting things. Which are the main problems when we deal with legal translation? Of course, we have very technical issues like translating legal concepts. Private law is full of very technical concepts that are culturally bound and that are difficult to translate even towards another European language. So that is why, for example, we were following with great attention all the process of harmonizing, for example, contract law or tort law at European level. But then there is also another problem. When we translate, it depends on what you translate, of course, but if you have to translate a text, an article, you would like to render a specific style of the language from which you are translating, right? So we generally recognize that each language has a specific genius, a specific style, and that this style is changing over time. So it might not come into question when we deal with international treaties, but when we deal with works of scholars who interpret local law or even international treaty during time, this can make a difference. And that, of course, there is the problem of detecting values that are not expressed in writing, but are immanent in a specific community and influence the interpretation of legal concepts. Sometimes I take very simple words and I tell them to my students in a provocative way. And for example, in front of the class, I go to the girls and I say, "Are you okay with your dowry? Did your father have enough dowry for you and for your sisters?" And they remain, "Dowry? La dote," in Italiano. What's Professor Pozzo has become crazy. Yes, are you okay with the dowry? Did your family agree in paying the dowry for your engagement or for your marriage? And they begin like that. And then I begin to say, did your grandmother have to pay a dowry to get married? Or do you know when we abolished the dowry system in Italy? And then they begin to reflect and to think about how much the word dowry in Italy does not mean anything now, could have had a very important meaning maybe under the fascist period, but is still very important as a word and has a lot of immanent values when we speak about the dowry system in India. So translating dowry with dote, of course it's easy, but the heavy, I mean, the word in Hindi, in English, translating the Hindi word is much more important than in other contexts. Then nowadays, as far as languages are concerned, we of course are debating a lot of questions, and when we deal with languages that are very important today, like Chinese or Japanese or other languages that are very difficult for us to understand and to learn, we generally have to be very well equipped and work together with somebody who knows the language and who knows the law and who knows the culture, because otherwise working with translations, I have tried to work with translations of Chinese environmental law into English. It's a desperate situation because you don't understand the English. Okay, and so there is the issue of working in a multilingual world, because of course English, it's a good thing to communicate, but multilingualism is actually what characterizes the world nowadays. And we see that there are a lot of harmonization processes going on. And the idea of studying languages, and especially legal languages for harmonization purposes, is one field of comparative law research, especially in Europe, when the European Union is using, well, we have 24 official languages, as you might know, but 98% of all the legislation in Europe is drafted in English, which has a certain impact on the way directives are written and then translated. I don't know what's going to happen with Brexit, but for the time being, English is still, you know, our favorite language. And of course, being the most spoken language has also some disadvantages, because it is the language that is going to be hybridized, if it is possible to say it, in order to introduce neologism and new concepts that are coming from other cultures. And these are debated issues in the comparative law research right now. Then the analysis of legal formats. I think I have. Yes, the idea goes back to a work of Rodolfo Sacco of the 70s, but it was published in English on the American Journal of Comparative Law at the beginning of the 90s. And what is Rodolfo Sacco saying? The traditional point of view in Italy and in other civil law countries until the 70s was that the law is the one that is in the legislation, the one that is in the code. And the idea of Rodolfo Sacco was, well, let's be more careful, because when we look to the law in action, we see that there are many different formats that contribute to the interpretation that we are going to find in praxis. And these various legal formats that contribute to the law in action may be, in Western countries, statutory rules, the formulation of scholars, the decision of judges. But when we move away from Western legal tradition, of course, we find customs, traditions, religious beliefs that all contribute to understand how the rule in practice work. And then the idea developed by Hart and Sachs. So there is a very interesting story behind this book, which is called the most famous unpublished book. Because Hart and Sachs went on teaching on these books for all the 50s and 60s without publishing it. And it was published only later, when I think one of the two had already died, because the dean of their law school was very eager to have these materials to work on with students. And the idea is, why do we have in some cases identical rules that work in very different ways? And so Hart and Sachs were pointing to different issues, different variables that are outside the rule, but that really condition very much the application of the rule. So, for example, if we have a rule on strict liability for environmental harm, how much will influence the application of the rule the fact that we have very well organized environmental associations, or the fact that we have law firms that are very eager to organize class actions in the field of environmental law, or the fact that we have punitive damages, or the fact that we have contingency fees. Do these variables that are outside the rule that we are comparing not influencing the application of the rule? Or, for example, I was quoting this example at lunchtime before. Sometimes you have perfect rules that do not work in some particular context, because they should be applied also by women, and women do not dare to ask the application of a legal rule that might correspond to a violation of traditional standards of behavior towards the family. So then legal transplants or diffusion of norms, you can call it when how you like it. I go back to the terminology that Alan Watson was using at the beginning, and legal transplants have always existed, have always been studied, only that nowadays with globalization and with a very rapid circulation of legal models and or diffusion or inspiration of legal norms everywhere, this issue has become very, very important. Rodolfo Sacco was saying 40 years ago that a system or a legal system was circulating because it was imposed by weapons or was copied by prestige. Nowadays, it's not like that anymore. So it's not a choice between prestige and weapons. It's not that that Napoleon is going to invade Italy and impose the civil code, but there are other ways of imposition or influencing, and these are, of course, are very important to detect, especially when we speak about environmental law, because these are very, very interesting phenomena that we can observe. And of course, the idea is not simply, the idea behind is not to say, the German system, fantastico, everybody's copying it. No, the idea behind is to see why that model has been copied or has been taken as inspiration, and how it works then once transplanted, and which have been the problem once transplanted, if the result that was reached was exactly what they wanted to reach or not. I was once called by a very nice colleague from Torino because he was asked by a group of lawyers of Azerbaijan to meet, and it was for me it was a very interesting opportunity to see how sometimes things work. And these lawyers of Azerbaijan were asking me, which is the best law the directive did not exist yet, but which is the best law on environmental damage in Europe? I said, well, there is no best law. It depends on which is the set of legal procedures, if you have courts, which is the world behind it, right? No, I'm not. I have a little bit more. Sorry. So this is what sometimes happens. So that there are people asking, I want the best rule, but this is important. It is nearly impossible to say, and so the work of comparative lawyer is very different. So are these tools, can be these tools helpful in comparative, in detecting what global environmental law is? Of course, various trends towards globalization of our environmental law have been described and analyzed by environmental lawyers. For example, the development of global trade and multinational corporate enterprises that have putting pressure to the harmonization of environmental standards, and many others. I don't want to go into detail because I don't have time anymore. But anyway, the work of NGOs, of financial institutions, the idea of international cooperation, but also private individuals. There are interesting articles about the fact that contracts are nowadays written in such a way that you find environmental clauses in contracts, in international contracts that are all over the same. So as a result, it is true that you can find the same rules in Italy, in Brazil, in China, or India, so that you can really see that there are trends, global trends emerging. But this idea of having common trends that are developing have been studied from the point of view of comparative law, and the idea behind is to first understand how do these legal transplants happen. So is it because as sometimes happen, the Chinese government has been influenced in the past by German legislation and is willing to go on in this direction. And you can find publications where it is really openly admitted that some statutes on environmental law, Chinese environmental statutes, have been inspired by German pieces of legislation. But the other question is also in the comparative law research, are these legal transplants happening voluntarily, in the sense, is there a will behind the European Commission to do something that is exportable or not, for example? And another thing, why did the wind change? Because much of international law was until recently inspired by America, by United States law, and nowadays it's not so much anymore. And then at the end, which have been the results of these legal transplants? I'm not going to read this quotation by Philip Sands, but Philip Sands in The Greening of International Law was clearly stating in 1994 that much of international law was inspired by US law, and that is why, and that is because United States law was really à l'avant-garde until that moment. So now this role as pioneer did not exist anymore after Bush period, I would say, and I don't say anything about Trump. Nowadays, we see, and there is literature on it, that there is a Brussels effect on global environmental law, and it is not by chance that Korea is this time really copying and pasting the REACH regulation. Why? Because they want to sell chemicals to Europe. And then, of course, there is this way of transplanting legal rules, because not because the European Union wants to impose to Korea to adopt REACH, the REACH regulation on chemicals, but because it is convenient for Korea to have the same standards in order to be able to export to Europe chemicals without problems. So I have put this quotation by Percival and Young because I don't agree with them. Not because there is no global law. Of course, there are global trends. But what I don't agree with is that, let me read it. While comparative law scholars in the past might reasonably have described the movement and transfer of concepts from one national legal system to another or to the international system as acts of borrowing, global environmental law indicates that this description has become inopposite. But that was not the aim of comparative law research. We are not looking for borrowings in the sense to say, but the German model was copied. But what we want to understand is why did it happen, or not which system is better, but much more how law develops. So the perspective of the borrowings of the norm diffusion remains. I think it is very important to understand why it goes on in one direction or in the other. And this is the quotation of the Supreme Court of India that I like very much, because it's not only a questioning of borrowing or introducing legal norms. It is a question of effectiveness of implementation, which brings down to earth then the legal principles that we are investigating at first sight. The Supreme Court of India in 1996 was already saying if the mere enactment of laws regulating to the protection of the environment was to ensure a clean and pollution-free environment, then India would perhaps be the least polluted country in the world. But this is not so. So if we look just 3 minutes, okay, 3 minutes, I have it. If we look to a question that I was investigating more carefully than others, that is to say liability for environmental harm, and we have the directive. We certainly have, first of all, a statute of an American federal statute of 1980, the CERCLA statute, the Superfund legislation that I have not put here, but we have different examples of the Western legal tradition. But when we look to what happened in Mexico, China, and India, what are the important issues that were happening? Thank you so much. Grazie mille. You perfectly understood. Thank you. So, the Mexican law on Mexican Ley Federal de Responsabilidad Ambiental, it's a gorgeous statute, wonderful statute. All the questions that the European directive did not approach, because the European directive was really a diplomatic compromise reached 4 days before the entrance of 10 new member states into the European Union. So it was really, after decades of working, take it or leave it. Okay, so the European directive has been adopted, I think, the 23rd April 2004, and the 1st May 2004, 10 new member states were entering the European Union. So it was really, this is the best compromise that we could reach, okay? The Mexican law didn't have all these struggles, so took all the literature of the European scholars over, and the Mexican law is simply fantastic. The problem is it is not applied. But, you see, there are different legal formats that we have to take into consideration. Chinese law. Chinese law is of course, very interesting. It's impossible to get into details because, of course, time is very little. But I just wanted to give you a few details. The Chinese law is copying the German legal system, and in particular the Chinese tort law of 2009, which has a specific chapter on environmental liability. In the parliamentary works in China, it is crystal clear, they say it very clearly, they are copying some norms of the German statute, okay? So let me give you one problem of translation. So the German statute is is introducing strict liability. It uses, of course, the German term, Gefährdungshaftung. Gefährdungshaftung means, literally, a liability that is arising out of the fact of having generated a risk, Gefahr, risk. Okay, so then it had to be translated into English because not everybody reads German. So they began to think, well, what is this Gefährdungshaftung? Well, it's a strict liability or a no-fault liability, which is the same in the German vocabulary. Only that, not knowing exactly what was behind the concept, now we have two different Chinese case law trends. One say, oh, no, it's a strict liability. No, it's a no-fault liability. They are not exactly knowing that they are coming out of the same concept, but the evolution, the discussion that has been developed in China comes out of a lack of definition of what was this strict liability. Okay, the other thing that I would like to point out is that sometimes I hear China has become a civil law country, so it is copying from Europe, or it is copying from civil law countries. Well, pay attention, sometimes yes, sometimes no. The lender liability issue that was developed in the United States was not taken over by the Chinese law, but the Central Bank of China took it over in a regulation because they thought it was interesting. So sometimes different legal models, different legal origins may even overlap. I cannot go into detail, and I just want to point out the last example on Indian law. Indian law is, of course, based on English law, and we find of the Raj period, and we find the same concepts that we would find in the European Liability Directive, but also in other tort law cases of British origin. But the Indian judges and the Indian courts were very activist, and so they had no problem in saying, for us, Rylands against Fletcher means absolute liability, or to take over institutions of the American jurisdiction, like the public trust doctrine promoted by Joseph Sachs, or to launch a public interest litigation that works practically in a very different way from the one that works in China. So I have to conclude. So I think that we have very different starting points, comparative lawyers, but from international lawyers, and especially from those ones who are very much devoted to the idea of a global environmental law. But I think that these points of view are complementary, and I think that it is important for the comparative lawyers to understand which is the agenda at the international level in the environmental field. But I think it would be appropriate if these tools of a comparative law investigation would be known by those who are struggling towards comparative to global environmental law. So as a conclusion, I would like to take away the question mark and put an exclamation point after comparative legal method for global environmental law research. Thank you.